Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Nelson, Ms. Higgs, and Ms. Spengler. And the people are represented by Mr. Brockler, Ms. Pearson, Ms. Titch McGuire, and Mr. Edson. We are outside the presence of the jury. Did you have an opportunity to redact the exhibit that was being played yesterday at the end of the day, P-TR-1008, Mr. Brockler?
We did, Your Honor. We also provided a copy to the defense last night. I also had Dr. Reed go through it to make sure that those changes had been made, and we have a new disc that contains that entire section on it.
Okay. And so how do you want to proceed? Do you want to just keep playing the new disc, pick up where you left off yesterday and start playing the new disc? Or I suppose that's the best way to do it so that the jury doesn't figure out that there was a redaction made or something along those lines.
I agree with that, Your Honor. I do want to make the record clear in terms of the foundation that that disc is consistent with the court's order and reflects those redactions. If there's a way to do it outside the presence of the jury to make the record complete with the consent of defense, I think we ought to do that.
Well, Mr. King, have you checked the disc?
We have, Judge. We've checked it and double-checked it, and we firmly believe that it comports with the court's order.
In light of that, then, is there a need to have it, Dr. Reed establish any foundation, or can we just proceed with the redacted disc?
Can I have just a minute?
Yes.
That's fine, Judge.
We can just proceed?
Yes.
Okay, great. Let's do that then. So, Mr. Brockler, don't make any reference to a new disc or anything like that, and Dr. Reed should not make any reference to a new disc. We'll just treat it as though it's the same disc that was playing yesterday.
And, Your Honor, are we going to then treat this exchange, just for purposes of the future record, as a stipulation as to the foundation of this disc with the changes that have been made? Without giving up on any other prior objections as to that have been made.
Yes, my understanding is the defense is simply agreeing that the new disc, and when I say the new disc, I'm talking about the new version of P-TR-1008 that's here today, is the same as the version of P-TR-1008 that was here yesterday, that was being played for the jury yesterday, and that was stopped, with the only exception that the one today has the redactions that we talked about, which appear at paragraphs, I believe it's 81, 84, and 87 of Motion D-264, small a. Right, Mr. King?
Yes, Judge, and it occurs to me that we probably should relabel the original exhibit as a court's exhibit at this point, so it doesn't get confused with the correct one.
All right. When you say the original, I want to make clear that you're talking about the one that was actually playing yesterday.
That's right. That's the one I'm talking about.
Because there's been another version of this tape already introduced as a court trial exhibit. That's the one before the sound was enhanced. So we'll mark this one. What's next? Is it 41? Are we up to 43? It should be 43? Okay, so we'll mark the version of P-TR-1008 that was being played yesterday as C-TR-43. All right? With that, are we ready to proceed?
People are, Your Honor.
With the court's indulgence, may I make a brief record and motion regarding some of the testimony that, or videotape that the jury watched yesterday?
Yeah.
Your Honor, I would like to start out by saying that we maintain and in no way waive any of the objections or arguments that we've made in our previous motions D201, D221, D248, D249, and D264A with respect to the statements of Mr. Holmes on these videotapes as a whole, and also with respect to all of the specific statements identified in motion D264A. And having said that, at this time, the defense moves for a mistrial. The basis for this motion for a mistrial is that yesterday, as the court knows, shortly before we recessed for the day, the jury heard, played on Exhibit 1008, a lengthy discussion between Dr. Reed and Mr. Holmes in which they discussed the charged offenses in great detail. And this discussion that between Mr. Holmes and Dr. Reed was the subject of paragraph 70 in motion D264A. And while the defense maintains that all of the statements and all of the statements specifically described in D264A are admissible, we're moving for a mistrial now after the jury has heard these particular statements because Mr. Holmes' detailed statements about the offense are among the most problematic and unconstitutional from the defense's perspective. We do anticipate that there will be some more discussion of the offenses between Dr. Reed and Mr. Holmes in future videos, but this is, from my recollection, the first time on Exhibit 1008, which is segment 6 of the videotape, that they really get into the details about what happened in the theater, and so that's why we're making this motion now, after the jury has actually heard that evidence being played in the courtroom. As just a few examples among many others, the jury has now heard Mr. Holmes state in his own words that he shot at people who tried to run away, that he did so because he can't, quote, can't have people running away. They've heard his detailed description of his difficulty reloading the AR-15. They've heard his affirmative response to Dr. Reed's statement that you wanted to kill people. We've heard his response to Dr. Reed's question whether if anyone in the theater had made a surrendering motion, would you have shot that person? As well as his statement that he was prepared to shoot a theater employee taking out the trash if necessary. The defense maintains, as we always have, that the introduction of these statements violates Mr. Holmes' Fifth Amendment privilege against self-incrimination, his Sixth Amendment right to counsel and a fair trial by an impartial jury, his Eighth Amendment right to a fair and reliable sentencing proceeding, and his 14th Amendment right to due process, as well as Colorado Constitution Article 2, Sections 16, 18, 20, 23, and 25. And we also maintain the introduction of these statements violates Colorado Rule of Evidence 401 and 403. Even assuming some of these statements are arguably probative of sanity, many of them are far more probative of guilt, and so their admission creates a substantial risk for unfair prejudice that outweighs their probative value. We understand, well, and let me also say that the statements violate these constitutional and evidentiary provisions not only because of the content of the statements themselves, which directly discuss the charged offenses, but also because of the form in which they were introduced through a videotape of Mr. Holmes himself, providing what we maintain and have always maintained as compelled testimony to the jury. And we understand and we respect that the court has previously ruled on these issues in various contexts throughout the course of pretrial litigation in this case. But now that these statements have actually been introduced in front of the jury, we felt the need to make a further record and request a mistrial. And lastly, I would add that because of the way the prosecution has chosen to present its case, these statements are being introduced affirmatively in the prosecution's case in chief, rather than in limited rebuttal to specific evidence of insanity that's been presented by the defense. In other words, they're being used by the prosecution on offense rather than in defense, and they're not being selectively introduced in response to specific evidence that we've actually introduced. And we understand that they ultimately have the burden of proof on insanity, but Dr. Reed's testimony is being sandwiched in between other evidence and testimony that bears on guilt, not sanity. And the context in which these statements are being presented makes any limiting instruction especially ineffective. Now, the U.S. Supreme Court in Buchanan v. Kentucky and Kansas v. Cheever, which are cases that we've cited extensively in our pretrial motions on this issue, discuss evidence from a court-ordered psychiatric examination as admissible for a limited rebuttal purpose. And the Cheever court specifically has acknowledged in a footnote, the Supreme Court pretty clearly stated in a footnote in Cheever that its holding suggests a constitutional ceiling on the scope of expert testimony that the prosecution may introduce in rebuttal in cases like this. And it didn't resolve conclusively what that ceiling is because that issue wasn't before the court. But it's our position, and this is a new argument in addition to the arguments that we've already made pre-trial on this issue.
Let me stop you there. This new argument is untimely. This new argument should have been made before Dr. Reed testified, not now. Why are you making it now? If you're gonna, hold on, if you're gonna make it now, make it an appeal, or make it later in a post-conviction proceeding if there is a conviction. It doesn't make sense to make it now. What can I do now?
The motion is a motion for a mistrial, Your Honor, and we believe it's timely because
Ms. Nelson, as a lawyer, you can't wait until evidence is presented and then object and say, wait a minute, this is unfair. They're calling Dr. Reed an offense. They shouldn't be allowed to do that. Dr. Reed has been on the stand now for what, 5 days? You can't, if you were going to object to that, you should have objected before he took the stand. So as to that argument, it's untimely. And you can't raise it at this time. I can't do anything about it. Now, in terms of the other argument, if you want to continue to supplement the record, I'll let you do that. But this argument about the prosecution improperly calling Dr. Reed in their case in chief, that argument is untimely.
Perhaps I can clarify a bit for the court. I understand what the court is saying. I do. And we did not object to Dr. Reed's testimony in general when he took the stand. The reason that we're making this specific motion at this particular time is because it relates to the introduction as a whole of the statements about the offense, which were played for the jury yesterday.
Right, but you said that at least your last argument, Ms. Nelson, has to do with the fact that the prosecution put on this evidence in their case in chief. And what I'm telling you is, to the extent that you think there's anything unfair about that or anything improper about that, this argument is untimely. And I'm not going to hear it now. You can raise it later. You should have raised it if it needed to be raised before he testified. So to the extent that you're saying there is anything unfair or improper about either the videotape or Dr. Reed testifying at this juncture in the proceedings, that argument is untimely. I'm not hearing it right now.
I understand the court's position, and I respect the court's ruling on that. I respectfully disagree because the argument is targeted specifically at the statements about the offense, which didn't come into evidence until yesterday. And just for the purposes of the appellate record, Your Honor, I would request an opportunity to finish my argument and make a complete record on that point.
Well, I think you've made your record. Is there anything else you need to add?
Well, in addition to Cheever and Buchanan, I would like to cite to People v. Rosenthal, 617 P. 2nd, 551, Colorado, 1980, which is distinguishable somewhat on its facts, but I think applies to the situation because it involves the prosecution's affirmative use of statements that were made in a psychiatric examination during their case on the merits. So for these reasons, we respectfully move for a mistrial at this time.
With respect to your other argument, let me ask you, did your expert on mental health, Dr. Gurr, speak to your client about the offenses?
Yes.
Okay. All right, thank you. Does the prosecution want to respond?
Only to say two things. One, this is a complete surprise to us, and if the court had expected that we would confer with each other before making such written or oral motions, as this is not an objection, this is a motion. That didn't happen here, Your Honor, and I was surprised to have Ms. Nelson take the podium and raise this, and we are unprepared to rebut in greater detail. Having said that, other than the issue that the court addressed as untimely, I'm unaware of any new argument to be advanced by the defense that hasn't already been addressed by this court, and we would rely upon that prior ruling.
All right, thank you. First of all, Mr. Brockler is absolutely right. Counsel should have conferred before they raised this motion, so that was improper. I have said before you raise issues with me, you have to try to confer and try to come to an agreement on them, or at least let the other side know, just out of professionalism, let the other side know, hey, we're intending to raise a motion for mistrial. That's the, I think, just a courteous thing to do with opposing counsel. So that was improper. That's number one. Number two, I think to the extent that there's a new argument about the juncture in which Dr. Reed is being called, or the videotaped interview by Dr. Reed or the defendant is being played, that argument is completely untimely, and it is rejected on that basis. I am not addressing the merit of that argument because it is untimely. There's no difference between that argument being raised now or being raised later at a later proceeding. There's nothing I can do at this point. I'm not going to call a mistrial because the defense either forgot or chose not to raise the argument in a timely fashion. It doesn't work like that. So that argument is rejected as untimely. And despite what Ms. Nelson attempted to do at the end in terms of rephrasing the argument or in terms of explaining why she was raising it and connecting it to the previous argument, her argument was clear that she thinks it's improper for the prosecution to call Dr. Reed on offense, as she put it, or to play this videotape on offense. That argument, if it was going to be made, should have been made before Dr. Reed took the witness stand. There was no motion made. There was no objection at all. The defense knew when Dr. Reed was called because the people said, we called Dr. Reed, and Dr. Reed took the witness stand. The defense was silent on that issue and can't be heard to complain about it now. In terms of the other arguments, to the extent that these are arguments that I have already addressed, I stand by my rulings. So to the extent that it's just repeating the same arguments, I reject them for the same reasons I have rejected them before. As I explained in one of my previous orders, by definition almost, a court-appointed sanity examiner has to talk to the defendant about the offenses in question. Dr. Metzner did that, and I don't recall there being an objection with respect to that as it relates to Dr. Metzner, but there's an objection with respect to that as it relates to Dr. Reed. The defense's expert did that. And obviously that was with the defense's consent. You can't have it both ways. You can't say, well, if we like what an expert ends up saying, or if we like the evaluation, then it's okay for the expert to talk to our client about the offenses in question. But if we don't like it or we don't think it's favorable, then we're going to object to it and say it's unconstitutional. You can't have it both ways. And so there's nothing improper with Dr. Reed having talked to the defendant about the offenses in question. Of course he spoke to the defendant about the offenses in question. I asked him to do an evaluation and to determine whether Mr. Holmes was sane at the time of the commission of the act. He has to talk to him. He had to talk to him about the offenses in question. To the extent that there was an argument or an objection that was aimed at specific statements in the videotape, and that it's not just an objection to having Dr. Reed generally talk to the defendant about the offenses in question, those objections and those arguments are untimely. They should have been raised in motion D-264 small a. That motion, by the way, was a lengthy motion, and my order was a lengthy order, and I went through each objection in that motion, and based on my analysis, I order that the videotaped interview be redacted in some places. In other places, I ordered that it didn't need to be redacted. It didn't need to be redacted. To the extent that the objection is to specific questions or specific statements in that videotape, those are untimely. Those should have been raised in motion D-264A. And so to the extent that those are different than just a general objection to having Dr. Reed speaking to the defendant about the offenses, those arguments and objections are rejected as untimely and improperly raised as well. So for all those reasons, the motion for mistrial is denied as meritless. All right, let's bring the jury in, please. No, we're done. Thank you. Let's bring the jury in, please. Please be seated, everyone. Good morning, members of the jury. How's everyone doing? Good. It's good to have you back. As you might remember, at the end of the day yesterday, the prosecution was in the middle of publishing People's Exhibit P-TR-1008. And my understanding is that the prosecution will resume publishing that exhibit where they left off yesterday. Before they do that, however, I want to give you the instruction that I've been giving you throughout the publication of the videotape. And so I want to remind you that the defendant's statements on this video recording have been admitted only for a limited purpose. You may consider the defendant's statements on this video recording only as to the issues raised by his plea of not guilty by reason of insanity. You shall not consider them for any other purpose. Dr. Reed's statements on this video recording may only be considered for the limited purpose of allowing you to evaluate the reliability of his examination and to provide context to the statements made in the video recording by the defendant. You shall not consider any statements or questions by Dr. Reed on this video recording for any other purpose. All right, with that, Mr. Brockler, do you want to proceed with publishing People's Exhibit P-TR-1008? Yes, Your Honor. All right, you may proceed.
There was a guy there, a guard there. What are you doing with the bags on your hands?
Oh, he's doing like sock puppets or something.
Then what happened?
Then they took me down to booking and did all the fingerprinting, strip search, all that stuff.
As you're at the station and it's done, not only is it done, but you're now contained. What's the feeling that you have?
What's going to happen next, kind of a thing.
Okay, what's going to happen next? Any other feelings come to mind?
Just that feeling that it's finished.
Was there anything else? You said finished. Can you think of anything else that needed doing?
No.
Eventually, they took you to the Arapahoe County Jail.
Right.
How long afterward was that the same day that they took you to the Arapahoe County Jail?
What's the question?
Did they take you to the Arapahoe County Jail on the same day?
On that Friday, yeah.
So you didn't have to spend the night in a lockup at Aurora PD?
I was in the interrogation almost all night. And they took me in the morning.
Did they offer you any food or water or things
In
like
the
that?
jail, yeah.
Chance to use the restroom?
I was in a cell with a John.
Once you left the Aurora County Jail, did they tell you where they were taking you? Or the Aurora lockup? Did they tell you where they were taking you?
No, they didn't tell me. They just took me there.
Okay. What was it like to go to court? You've been in court several times. What was it like the first time, for example?
Oh, I don't remember what. I think I was just trying to pay attention.
The first time you went to court, they would have had to bring you from the Arapahoe County Jail to court, right?
Yeah, there's a tunnel underground that goes, yeah.
And you're sitting in court for some procedure hearing. I'm not sure I know the name of it. There's a judge. You're sitting there. Your lawyer. What do you remember about that event? judge talking?
I know he talked. I don't remember what he talked about.
Remember anything about being in court?
No,
What the room looked like?
it's the same room that I've been in.
Okay, what does the room look like? What's it look like?
It's hard to describe the room. Well, there, the jury seat. The jury walks to a table. I sat at the table.
Okay.
The prosecutor sat at a different table.
Did it make you nervous to be in court?
I don't think so, no.
You've got somebody up there, the judge,
I don't have to do anything, I just sit there.
but the judge has got his fate in your hands, and it's out of your hands. And he's got your fate in his hands, and it's out of your hands.
Right. So there's nothing I really need to do.
Do you like it when your fate's in other people's hands?
No.
But it didn't bother you in the court? As far as you remember?
Right, yes.
How about other times in courts, hearings and things like that? Do you remember those times?
They all started to blend together. Oh yeah, I remember seeing specific witnesses and stuff.
What was the last time you were in court? Or roughly when?
Maybe 2 weeks ago, I think.
Do you remember what was being talked about in that hearing or that event?
Yeah, they were asking professional witnesses or professional experts on their procedures and qualifications.
Okay.
So firearms and tool marks specialists, gunshot residue specialists.
Okay. Of course, that's much more recent, and it's as you are today, not necessarily as you were 2 years ago. I'm real interested in how you perceived things in court 2 years ago, or 18 months ago.
Just that I wished it would go faster than it was going. Take it long.
Once you got to Arapahoe jail, Dr. Woodcock saw you there, I think, right?
Yeah.
Do you remember Dr. Sather?
Yes, I think he was the treating psychiatrist at the jail, maybe.
That may be Dr. Mosier.
That's Dr. Mosier, yeah. Dr. Sather, no, I don't remember.
Okay. Tell me about Dr. Mosier. What's your experience early on with Dr. Mosier, if you remember?
He just asked if I was having side effects with the medication.
Were there medications early on?
No, they came at the fall incident.
Okay. One of the things I seem to notice is that at jail, almost no one talks to you.
All right, they'll talk when they serve dinner, basically. Just like hellos and kind of.
If you were to talk to them, do you think they'd talk to you more or not?
Oh, yeah, I think they're open to communication.
Here, people talk to you a lot.
There's not much else to do, I guess. Yeah, they talk a lot, so that's a downside for me.
That's a downside for you. So the fact that this is a little more, slightly different word, a little more social place, is a downside for you? Is that what you would say or not what you would say?
Yeah, it's fair to say.
Okay. With the note package? You remember what else you sent with the notebook?
Can you give me some sort of context?
What else? You remember what else was in the package besides the notebook?
Burned currency.
Tell me about the burned currency.
Well, I figured I wouldn't have any use for money afterwards, so I destroyed the currency.
Was that all your money?
No, it was about as much as I could take out from the ATM machine.
Tell me what that process was. What did you do in terms of getting the money?
I rode my bike over to the ATM machine and tried to pull out as much money as I could with my debit card and my credit card.
How much did you get?
I think $400 or $600.
Okay. What day was this?
I don't know.
Was it the day that you mailed it or close to that day?
It was close to that date.
Okay.
Early July.
So you took the money out. What were your thoughts as you decided to go get the money, as you got the money? One thought you mentioned, that I won't have much need for money.
Right.
What else? Any other thoughts? Or?
No, not really. That was the main one.
What did you think Dr. Fenton would think or infer from finding the money in the package?
Well, one of the reasons I didn't stay with Fenton was because my insurance was going to get canceled because I dropped out graduate school. And she charged like $80 an hour, so it would have been unreasonable to have sessions without the insurance.
What does that have to do with sending money with the notebook?
That money didn't matter anymore.
But I asked you what Fenton would think, and your answer was something having to do with what she charged for sessions. I don't understand the connection between that and the money that's in the package.
Money was a factor in me not continuing on the therapy with Fenton.
And we know that. But why put money in the package? You weren't going to have any more sessions.
Right.
Why send her money?
Well, send her burnt money.
Why send her burnt money?
To show that was a reason why I didn't come back to her.
At the time, did you expect that she would put all that together? Because it's very confusing to me.
At the time, I don't know what I was thinking.
Any other reason you think that you included the money, particularly that it was burnt? It was burnt in a certain way, wasn't it? On the corners.
Yeah, that didn't mean anything special.
Okay. Why was it burnt on the corners and not elsewhere?
So it could still be identifiable as money.
Okay. And once again, what she would think when she opens it up and sees burnt currency, what do you think she was likely to think about that, or to think that you were communicating to her?
That money was an issue.
An issue for?
For the shooting.
That money was an issue for the shooting?
Yeah.
That's what you just said. I don't understand.
Well, if I'd stayed and got further treatment from her, I might have not done the shooting.
Okay. That also kind of tells me that you had money that you could have paid her to stay. You could have covered the sessions.
Yeah, I could have paid for it.
At the time, the thing you said to them, to her and Feinstein, were that you were no longer a student, so the sessions wouldn't be covered. My understanding is they said we can find a way to deal with that. Did you ever, as far as you remember, think or mention that you could cover some sessions yourself?
That's true, they offered more sessions in the summer, but there would still be the problem of having therapy ended and then having no renewals for the drugs.
Do you really think that that would have interfered with your getting prescriptions? Is that really what you think was
Yeah, I think
a
it
reason
would
that you couldn't
stop
continue?
the prescriptions.
Yeah. That's not what they were telling you, though, was it? They were telling you that they could continue the prescriptions and continue the visits.
Up until the insurance was out.
And you had lots of money in the bank.
Right,
And your folks had money.
yeah.
You stopped. You decided to stop seeing them. And left at that point and said goodbye, right?
Yeah.
Okay. I want to move to something else that won't take very long, but is there anything that, I guess particularly the attorneys have said that you really should let me know that I haven't asked about or you haven't thought to mention?
No, they just said, be yourself.
Can you think of anything that I ought to be asking about, but I'm not asking about?
No.
Anything that you'd like to share with me that you haven't shared with me?
Nope.
Okay. May I take your pulse again?
Okay.
Thank you. Thank you. Now let me go to another area here. I promise it won't interfere with dinner, okay?
Okay, good.
You talked about how depressed you'd been. You talked about the possibility that you had a mania of some sort.
Yeah,
You called it dysphoric mania.
right.
I think we asked if you'd had other symptoms that you thought were associated with mania. And some of those that we might not have talked about was times when you didn't need sleep. You mentioned that you had difficulty sleeping.
Yeah,
Were there times when you didn't need to sleep more than 2-3 hours a night, 4 hours a night?
not that I can remember.
Okay. Times when you went out and bought lots of things that you didn't need. Spending sprees, if you will. Major spending sprees.
Yeah, on all the weapons and armor and stuff.
You've described a purpose for those things.
Right, so I didn't need them.
Okay. It's not like they piled up in your apartment in unopened boxes or something. They serve their purpose, it sounds like.
Yeah.
Anything else that you spent a lot of money on in the 5 or 6 months of early 2012?
No, not really.
A lot of this we've already covered in the course of our chats. You mentioned PTSD. And then you mentioned that you couldn't think of an event.
Which cause it? I think it's more chronic stress.
You've now had a very stressful event.
I don't think I have PTSD.
Okay, then that was my question.
Okay.
Are there times that you think a lot about the shootings?
Well, in
Even
court, they bring it up.
How about when you're not in court? sitting in the jail, sitting here?
Well, the jail reminds me of the shootings as well.
Are there times when it comes back to you and vividly?
Kind of intrusive and vividly, yeah.
Okay. You said kind of intrusive, is that what you said?
Yeah, intrusively.
Okay. In those times when it comes back vividly, do you recall or experience things differently from what you just talked with me about?
No, I don't go through the whole shooting like that. I just kind of think about there's a shooting.
Can you think about it? And your thoughts when you think about it, in what way do you think about it? What is it? What's the effect of your thinking about it?
I don't know.
What effect does it have on you to think about it?
It has a kind of distraction, kind of a distracting effect.
Distracting?
So it distracts me from sitting alone in my cell.
Okay. Something to distract you. Any other effect it has on you?
No, I don't think so.
Distracting when you're sitting alone sounds a little like that might be a good effect, something that would pass the time for you, but I may be misunderstanding that. Am I misunderstanding?
It does pass the time, but I wouldn't say it was a positive thing.
Okay.
All right.
Your reaction when the thoughts come up then is what?
That I don't want them to come up.
Okay. What do they make you feel?
I don't know.
Sad, angry, disappointed, depressed, nervous, happy?
I guess they don't make me feel anything.
Okay. Are there times that they come back so vividly that it's almost like reliving them?
Well, reliving them with those kind of chunks missing in the video.
At any time in your 2 years in jail, have they come back so vividly that you could hear or feel or see?
No.
Okay. Okay. I've seen a lot of your medical history and medical records from the past, but let me go through just a couple of things with that. Have you ever had a serious illness before?
No.
I'm aware that at one point you had mononucleosis.
I wouldn't consider that serious.
Okay.
Lots of people get it.
And we talked a little bit about that, I think, day before yesterday. You weren't in the hospital for it. You didn't even see a doctor for it after you came back to Colorado, right?
Right.
Okay. Ever have an illness that put you in the hospital?
Like ear infections when I was like a baby, I think. But that, I don't know if that counts.
Okay. Any other illnesses that put you in the hospital?
No.
When you were a baby, ear infections or something else, do you know how long the longest time you were ever in the hospital was?
Just a normal visit's worth 3-4 hours.
Okay. As far as you know, not overnight or spending 2 weeks away from home in the hospital.
No.
Any surgeries at all?
Wisdom teeth removal.
When did you have the wisdom teeth removed?
In high school, I believe.
Was that in office or in the hospital or where?
In the dentist's office.
Did they give you anesthesia or
Yeah, anesthesia and then painkillers for you.
put you to sleep?
Yep.
Any other surgeries you had?
No,
Tonsils, appendix?
no,
Anybody ever say that you had seizures or convulsions?
no,
Ever seen a neurologist before?
no, I don't think so.
You've had some medical exams in addition to the psychiatric, psychological exams. Within the medical exam, there are neurological tests.
Right.
Okay. As far as you know, those have never been particularly abnormal. Nobody's ever told you that they were abnormal.
The results, you mean?
Yes.
Well, they say it shows strong signs of depression
Okay.
and moderate psychotic symptoms.
And who is it that says that?
The person who gives me the test,
When did somebody tell you that?
well, just earlier today, Dr. Gary said that.
Okay. So he communicated that to you about some tests, about the test that you took?
The depression, at least, yeah.
Okay. How about the psychosis? Did he communicate that to you?
No, he didn't mention it.
Where did you get that?
From the last time they administered the test, I think they said that.
So someone talked with you about that as a result
Of the test.
of the psychological test? Okay. Okay. When the falling episode took place, you had lots of tests at the hospital.
I don't remember them.
Really?
Yeah.
You don't remember? You remember being at Denver Health at all?
Yes, yeah. I remember them putting me in an ambulance and sending me over.
But you don't remember particular tests or CAT scans or whatever they did there?
I remember them wheeling the cart over, but I don't remember having the test performed.
Okay. Any other childhood diseases that you remember having? Or that your mom has said that you had, or somebody told you you had? Serious?
Pox, I think. Oh, serious? No.
Serious childhood disease? Your diet, while you were planning the mission, May, June, July, 2012, what was your diet like at that time?
Frozen pizzas, spaghetti, rice, chuck roast, chicken.
Were those usually things that you cooked, or
Yeah, things I cooked.
some were pre-prepared?
Frozen.
Frozen?
Yeah.
Did you actually cook some of them, like cook a roast?
I just baked and boiled some of them.
Okay. Any vegetables?
Mixed vegetables, soybeans, green beans, carrots, corn.
You're describing a fairly balanced diet. Is that
That's
reasonable,
what my diet was, yeah.
reasonable to say? A lot of sweets?
No, not really. I don't remember buying candy.
Lots of desserts, cake, donuts?
Donuts, yes. I would buy donuts.
How many donuts a day did James Holmes eat?
I was probably at one a day.
Okay. Did you smoke?
I tried it at the end, cigarillos.
About when?
Maybe like a week or 2 weeks before.
Did you regularly smoke anything?
No,
Tobacco, weed,
no,
any non-prescribed drugs?
no,
Meth,
no.
weed, anything? Okay. How about your caffeine intake?
Low, I would say, low compared to most people these days.
Okay. And you know basically what we're talking about.
Coffee,
Regular coffee.
sodas.
Certain teas, energy drinks?
No, I didn't drink any.
Really? Even when you were preparing?
Nope. I drank some in undergraduate, but never in graduate school.
Okay. Coke, Mountain Dew?
Yeah.
how many Cokes or Mountain Dews, Dr. Peppers, the ones with caffeine in them, how many per day would you drink of those, roughly?
Well, I drink it out of the 2 liters, so maybe a couple glasses.
Any homeopathic medications, over-the-counter stuff at the nutrition store, supplements kinds of things?
Just a daily vitamin.
Okay, daily vitamin. Anything else?
No,
You mentioned the depression and being concerned about that. St. John's wort, for example, is over-the-counter.
never tried it.
Okay. Okay. I think we're at the end of my part for now.
All right.
I'm not certain what else is going to happen here, but I think we're at the end of my part. Any questions that you would like to ask me?
Nope.
Not a one?
No, we talked about a lot.
I'm sorry?
We talked about a lot already.
Yes, we have. Any questions about what my role, my job is? We talked about the first day, but we haven't talked about it since.
No.
Okay. All right. I will wish you what I wish everybody I talk with. And that's that I hope whatever happens is fair.
All right.
Okay. Thank you for spending time and working with me.
Okay.
Okay.
I'm going to turn the lights back on. The record should reflect that the prosecution just finished playing Exhibit P-TR-1008. Mr. Brockler, do you have questions now for Dr. Reed?
I do, Your Honor. Thank you.
All right. Dr. Reed, I remind you that you're still under oath. And members of the jury, I remind you that the court has admitted the testimony of Dr. Reed only for a limited purpose. You may consider this testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. Mr. Brockler, you may proceed.
Thank you, Your Honor.
Judge, may I request the other limiting instruction as well?
The one on the video?
On the video.
Sure. Members of the jury, it is important that you remember that the defendant's statements on the video recording have been admitted only for a limited purpose. You may consider the defendant's statements on the video recording only as to the issues raised by his plea of not guilty by reason of insanity. You shall not consider them for any other purpose. Dr. Reed's statements on the video recording may only be considered for the limited purpose of allowing you to evaluate the reliability of his examination and to provide context to the statements made in the video recording by the defendant. You shall not consider any statements or questions by Dr. Reed on the video recording for any other purpose. All right, with that, you may proceed.
Thank you, Your Honor. Doctor, I want to start at the end, and then we'll work our way back through a couple of the major parts that you wanted to talk about with this segment. First, why do you go through sort of a detailed medical history of ailments and other things that we just heard with the defendant?
First of all, it's generally part of a complete psychiatric evaluation to at least ask general medical questions. Second, there are conditions that can significantly affect a person's behavior and their psyche. I'm not expert in all of those, such as a neurologist might be, but it's part of the general psychiatric evaluation.
Was there any information that the defendant gave you in that video that you found to be psychiatrically significant to your evaluation of him in this case?
There was. And let me find my note here.
Just let us know what you're referring to, and if it's helping you remember, let us know that too. Hang on one sec, Doctor. Can you just tell us what you were referring to when you looked down there?
I'm referring to around 16:07, hour 16:07, where we're talking about him sending the partially burned money along with the notebook to Dr. Fenton.
Let me do this just to make the record clear. Before you gave that answer, did you refer to some handwritten notes you took while you sat in here and watched the video with us?
Oh, yes. Yes, I took notes as I was watching the video.
Does referring to those notes remind you about what it is you wanted to say in response to my last question?
Yes, it does.
Okay, thank you. Go ahead, sir.
As I asked him about sending the partially burned money, the $20 bills with the corners burned, I was reminded as I was listening today that his memory of the explanation 2 years before was that the reason was not clear. It was something that was consistent with irrational reasoning, not necessarily irrational, but consistent with that. It was odd, and that's all I wanted to say about it.
Is that one of the things that you factored into your total assessment of his capacity to do the two things the court has instructed the jury about?
Yes.
I want to ask you, since we've jumped to sort of the money, I want to ask you, the answer that he gave to you was that he sent the money in part because he didn't have use for it anymore. Do you recall that?
That's what he said.
Do you recall from your review of the discovery whether or not the defendant had on his person at the back of the theater when he was taken into custody $280 in cash?
My memory is that he had a lot of cash. I don't recall the amount.
Back to the medical stuff. Anything else about the medical stuff that you talked about that you found significant in your evaluation of the defendant?
He ratified, that is, he agreed with the diagnosis of mononucleosis, or mono, at one point. He didn't think much of it. I can't think of anything else. Well, there is one significant negative. One of the things psychiatrists often ask is, are there periods in which a small child or infant spends a lot of time away from his parents, and that didn't occur with the defendant.
How about the diet? I mean, you went through quite a few specific questions about what he was eating and drinking and how much. How is that impactful in your assessment?
I was curious about and looking for the possibility that he was on some sort of bizarre diet that might have changed his emotional or physical functioning. A lot of sugar, lots of caffeine. You heard me also ask about illicit drugs or any kind of drugs. And essentially those answers 2 years later were nothing significant.
Is there something psychiatrically significant about someone who, leading up to an event, just lets themselves go, both in terms of hygiene and taking care of themselves, what they're eating, what you're talking about? Is there something about that? Is there a correlation to something?
Letting oneself go completely, not being clean, etc., would be consistent with someone who is not paying attention, perhaps for a mental illness reason. He didn't do that. I don't see anything really significant in the video about that.
You talk about early on, and I'm going back now to the beginning to touch on a few things. You talk about early on, again, this concept of value. Is there significance to the fact that he tells you that it is an arbitrary value, one that he created and sets, I guess, the value to the value?
Yes, it's significant to me that he didn't see that value as coming from God or some special organization, something outside himself. The arbitrariness suggests to me that it had nothing to do with some external power forcing him to do something, or a perceived external power or something forcing him to do something.
Does he ever indicate to you that he thinks it's a value that society would accept?
No, he says the opposite, actually. He says that this is a value because I say it's a value, and if someone else wants to talk about points, that's up to them. Depends on whether they happen to believe in their minds in points.
In terms of your assessing whether or not someone has capacity, I want to ask you about this question. You asked him if he had any doubt that he would end up killing a lot of people in the theater. Do you remember that?
Yes, I remember that.
Was that the purpose of that, was to assess whether he had the capacity to form the intent to act after deliberation?
It was part of the purpose. It was also part of the thoroughness. But I wanted to know whether he recalled knowing that that's what he was trying to do.
Do you ever recall him saying at any time, whether it's through these segments or the others, that he knew he'd hurt some people, but he didn't know he'd kill?
He never said that to me.
I want to ask you about, he makes reference to this, what you called to him a ruse with the cell phone in the front of the theater as he goes outside to then suit up. Do you remember that?
Yes.
What's significant about that?
It's significant for the strong implication that he was planning something and he was carrying out a plan, that those actions appear to be rational ones and reasonable ones, ones that might be expected of someone who didn't want to be discovered or didn't want to be stopped. It has to do with a kind of reasoning that if I do one thing, then another thing will happen. Let's say deductive reasoning. If I pretend I'm on the cell phone, people won't pay attention to my leaving to put on my stuff. A little broader way of saying that might be, if I leave my stuff in the car rather than walk my armament, my costume in the car, rather than walking through the theater, I'll be more likely to be able to carry out the mission.
There is a conversation that you have with him. Part of this conversation is about him changing into his outfit, and he detects someone come outside from the theater that he thinks is staff. Do you recall that?
Yes.
What was significant about that exchange back and forth?
He described perceiving. I don't believe he actually saw the person, at least as far as he told me. He describes hearing or perceiving someone he thought was an employee coming out to the dumpster or something. When I asked him about it, he said that if that person had interfered, he implied that he would have been willing to shoot that person. That is a rational way of carrying out a crime. It is a rational way of thinking. It is personal, for one thing. That's a person whose face he probably would have seen if that had happened, and we know that he didn't shoot that person. That's the way I think about it.
There's a reference to him having researched a number about the week before and then calling it when he's in the car changing to go into the theater. Do you remember that?
Yes.
What I want to ask is, do you know whether or not that phone number was a specific behavioral health phone number or just a general phone number to the CU hospital? Do you know?
I don't personally know what the number went to. He says he dialed it. I'm aware that a number was dialed and apparently answered, but I don't know what the number was.
What's the significance of his recollection to you that he called this number before going in and committing these crimes?
As he describes it, he still had some ambivalence about committing the crime, assuming it's judged to be a crime. There was a part of him that still wanted to be stopped, I believe, and a larger part, as he has said it, that didn't want to be stopped. It was one of the, I think he said, or I said, last resort efforts to see if someone would stop him.
How does that affect your assessment of his capacity to know right from wrong based on societal standards of morality?
He's aware that what he's doing is a bad thing, a wrong thing, and that if he contacts someone else or someone else is aware he's doing it, they will try to stop him because that person, the person he contacts, believes it's a wrong thing and he should not do it.
Despite what you've described as ambivalence and perhaps this conflict about should I, shouldn't I, Is there anything about that that tells you that the defendant was still not in control of his decision-making when he made the decision to go in there and pull the trigger?
He was apparently wrestling with things a bit, but there's nothing that says he wasn't in control of his decision-making, and he had certainly carried out his plan up to the time he made the call and was prepared to go further, so far as I know.
Now, up to this point, we have heard about the planning and the execution of this crime. Is there anything about that that impacts your assessment of whether or not the defendant perhaps was suffering an acute psychosis of some kind at this point?
The information available, both in the record and in the video, suggests that he was not suffering an acute psychosis. That is, although some of his behavior appears to have been odd, all of it, except for his explanation of the reason for sending the burned money, which he really didn't explain or couldn't explain very well, all of it was rational to his purpose, was focused, was not disorganized. That's a good word. There was organization in what he did. He was not disorganized to any significant extent in anything that I know of surrounding the shootings.
Well, why does that matter, the disorganization piece?
People who are suffering acute psychosis are very often, almost always actually, pretty disorganized in their thinking. It's one of the hallmarks of psychotic thinking, is that it's out of contact with reality and disorganized. It's not always terribly disorganized. If I believe I'm on Mars, truly, then I may well be psychotic and organized in thinking about Mars, or seemingly organized in thinking about Mars. But the fact that the processes that were carried out, the little ones and the big ones and the overall ones and the little pieces of them, were organized, had rational purpose with regard to the task or to the mission or to the killings, that's extremely consistent with not being in an acute psychotic state.
Now, this last part that I'll ask you about on this before we move to your next disc, was there a deliberate change in the way you questioned the defendant specifically about the collateral damage topic?
Yes, there was.
Judge, relevance to sanity in 403.
Overruled?
Did you change the way you did it, Doctor?
Yes, there was a small part of this video, I believe you're right, it was when we were talking about being in the theater and collateral damage, in which I became a bit more assertive. I think I asked questions a little faster, in part to see how he would handle that, whether he would keep up, whether he would become rattled, whether he would become confused and not be able to answer the way he had.
One sec, Doc. If he had, would that have been somewhat psychiatrically significant in your assessment of him if he had?
Yes, it would have been, as of the point that I examined him in 2014, it would have suggested that he was a bit more fragmented then. What happened, as I perceived it, and as it is on the video, is that he appeared to keep up with the questions just as he had before and didn't become upset or confused.
Thank you. Now, this next segment, which I think we've already admitted, 1009, when this last 1008 ended, we'd left with sort of, goodbye, my part is over, and yet now about 3 weeks or so later, August 27th, we have this other segment. Where is this other segment filmed?
The other segment takes place in the county jail, Arapahoe County Detention Facility.
Okay, thank you. Was the purpose of it something other than to just follow up on areas since you had a chance to go back over the first segments?
You're correct, basically, in the purpose. I had a chance to go back and look at this video, think about things, think about the various questions. I may have received a little bit more information from the record, and certainly thought of other things to ask about or to clarify, and asked if I could come back and was allowed to come back.
Your Honor, at this point, with the court's permission, I'd like to publish, I think it's People's 1009.
It is P-TR-1009, and it may be published.
Thank you. And
Doctor, you may step down again. Does it have a loud, annoying air conditioner? And I'm going to dim the lights. And actually, before you play it, let me remind the jury of the instruction again. Members of the jury, it is important that you remember that the defendant's statements on this video recording have been admitted only for a limited purpose. You may consider the defendant's statements on this video recording only as to the issues raised by his plea of not guilty by reason of insanity. You shall not consider them for any other purpose. Dr. Reed's statements on this video recording may only be considered for the limited purpose of allowing you to assess the reliability of his examination and to provide context to the statements made in the video recording by the defendant. You shall not consider any statements or questions by Dr. Reed on the video recording for the truth of their content or for any other purpose. All right, with that, you may proceed with publishing Exhibit P-TR-1009. I'm going to dim the lights again.
They wouldn't let me bring you any juice. Oh, he's pushed the button, I guess, so we're good. They won't let me give you any water. They want to supply everything for you.
Okay.
So, just to test, you remember who I am?
Dr. Reed,
And you remember the last time we met?
a couple weeks ago,
Okay, and where were we when we met?
CFHIP,
You're right. Okay. When did you find out that we were going to meet again? When did they tell you?
yesterday.
Okay. That's about when I told the lawyers a couple of days ago, so it happened relatively quickly. Sorry to spring it on you like that, but we decided to do it here at the jail. Less trouble. And I think we'll probably meet a couple of times today, morning and afternoon, just as we did last time. And we'll meet at least once tomorrow and probably twice tomorrow. Okay?
Okay.
Okay. And once again, I'm a little deaf, so I appreciate you speaking up. I'm not supposed to give you anything here either, so I won't. But I will read you the same thing that we had before, and you're welcome to look at it. It says that you're seeing me for an evaluation, and our purpose is a legal one, not a clinical one. We're videotaping just like we did before. Once again, I'm not interested in your legal strategy, but I'd like to learn as much as I can about you and what's happened and things like that. You know, as before, I'm working for the judge, and I'm not working for either side. But my report will go to both sides and to the judge. So your lawyers may well want to use it. Prosecution can use it if they want. But mostly the purpose is to just be as good as I can for the judge. Okay. All righty. And you and I are the only ones in the room. In the next room, we have our videographer and a couple of the custody folks, custody officers. They cannot hear us. My understanding is they cannot hear us. Are you okay with that level of privacy?
Yep.
Okay, thanks. The first thing I notice about you is that your pupils in your eyes are smaller than they were before. Did you know that?
I didn't notice.
Okay. You don't notice yourself because you don't check them yourself, but they're a bit smaller than they were before. Let me take your pulse, if I may. Thank you. I'm going to jot that down. Do you know what the date is today, James?
27th,
Correct. What month?
August
Of what year?
2014.
I figured you knew that. You know, I'm a little curious. How do you keep track of time in here? Time of day, day of the week, things like that?
Well, every Wednesday is laundry day. Every Friday is commissary day. So when they bring just like new clothes in, you know it's Wednesday.
Okay. If they weren't bringing your clothes, would you have a pretty good idea of what day it was? Or do they just show up and you figure it's Wednesday?
I also do it by TV shows.
Okay.
When the TV schedule's on.
Do you have a calendar in your cell?
Nope.
Do they allow you to have any kind of watch or clock?
I don't think so, no.
Okay. How else do you keep track of time? I've found myself thinking about that in terms of your isolation here.
Meal times, they're pretty consistent.
I notice when I watch video of you from weeks and months ago, you tend to go to bed pretty late and get up rather early.
Oh, they wake you up early for breakfast.
They wake you up. Okay. There's a window in your door, am I right?
Yeah.
Okay, and that's the only window you have in your cell except for one that's way up high.
Right.
What can you see from that window?
The door window? I can see the guards tower and the guards tower. And when they have their lights on inside, I can kind of see inside there in some detail.
Okay. I mean, you said the guard's tower, that's indoors, not outdoors, is that right?
Right.
Okay. And tell me about the way the lights work. Is it the light is on all the time or no? How do the lights work out?
There's a light switch in the cell that turns on and off the main light, but then there's also a light that's always on that I don't have control of.
Okay. That light is bright enough for me to see video of you when you're asleep. How bright does that light seem to you?
I guess I'm used to it, but I don't really notice it.
Could you read with it, for example?
I could, but it would strain my eyes.
If you wanted to turn your light on at 2 in the morning, would that upset anybody or?
No, because I'm in a cell by myself. So.
Okay, so there's no lights out time?
No.
Okay. Thanks. Have you heard from your family since we talked about, it's been, you're right, about 3 weeks?
My lawyers haven't brought letters yet. So there might be like a couple.
They haven't mentioned to you that you got a letter? I don't know whether you did or not, but they haven't mentioned to you
I
that
think
you got it?
they mentioned they'd bring them on Friday.
Okay. So you think maybe there is one?
Yeah.
Okay. Did you have any thoughts about all the stuff we talked about in Pueblo?
I thought it was pretty thorough.
Okay. Any particular things that you left out or didn't leave out, or you might want to expand on or remind me of?
No, I don't think so.
Okay. Any thoughts about actually going there, staying there, and coming back to the jail? How'd you feel when you left there?
Just that I knew the food wouldn't be as good.
Food not as good, okay. Anything else? Another difference is that the people at CMIP, or CMIP, I'm not sure what the acronym is. CMIP, okay. The people there spend a lot more time with you.
Right, it's definitely more interactive than
Yeah. Do you miss that a little bit, or no?
no.
Would you rather have it the way it is in the jail or the way it is at CMIP?
The way it is here.
Okay. Tell me about that.
Well, I don't like forced conversation where it is.
Would it have to be forced conversation? Might it be friendly conversation?
I guess so.
After you got back here, I believe Dr. Gurr came to visit you.
Yes.
How did that go?
It was like 6 hours long. It was okay.
That's a long time.
Yeah.
All in one stretch.
Yep.
Any particular stuff that you talked with her about that you'd like to share with me? Again, I don't want to hear anything about your legal strategy, but anything else?
No, not good.
Get along okay with her?
Yep.
I've never met her. I've talked with her on the phone. I did hear something about you. I think it was the SimHip visit before last. The staff said in the record that you could do something very interesting. They said you could recite the alphabet backwards.
Oh, they asked me to do that again.
Did they ask you again to do it?
Yeah, on this.
Can you do it?
Yeah.
Do it for me.
ZYXOUUTSRQPLMOKJIHGFEBCBA.
How did you pick that up?
I got bored on a long car ride, so I just went sequentially through the alphabet backwards.
Can you speak up just a little bit? I have trouble. Or maybe lean toward the microphone if that helps. On a long car ride before you were arrested?
Yeah.
Okay. And it just stuck with you?
Yeah.
How about the juggling?
I learned that before being arrested too.
Okay. Tell me about learning to juggle. I can't juggle.
I can only juggle 3.
Okay.
Some people can do like 10.
So do you practice juggling in the cell?
No, not really.
I saw you trying to do it early on. There, on one of the videos, I'm not sure what you're tossing, but
It's hard to do it with different weighted and shaped objects.
yeah. Yeah. Okay. There's several things I'd kind of like to talk about during the time we have together today and tomorrow. One of the things is I ran across your resume from a few years ago.
Okay.
And does that look familiar to you?
Yes.
Okay. I'm just going to hold it for the camera. It's a resume. It's not dated, but it looks like it might have been mid-2010. Maybe after you graduated from Riverside. The objective you had was to obtain a position as a clinical research intern with Novum Pharmaceuticals. Do you remember that?
I've done a lot of specific objectives.
So you might do a resume for each objective, is that what you mean?
Well, it'd be the same resume, but just have a different objective.
I understand. Tell me about your job search at that time. the jobs that you were looking for or looking at?
I don't remember much about job application.
Am I right that this was just after or just before your graduation from Riverside?
It was just after I graduated.
Was it tough to find a job, or were you optimistic about it?
Yeah, it's
What kinds of things were you looking for?
just a lab research position.
What sort of position? There are different kinds of positions. At that point, you're at a BS level.
Yeah, like a lab technician position.
Did you plan then to go into graduate school?
I plan to do those jobs in between going to graduate school.
Okay. And that was the period in which you had applied to several graduate schools. Am I right?
Yeah, I originally applied to a bunch, but didn't get accepted.
Okay. Did you get some calls back, have some interviews with some of those labs or some of those?
Only one with Irvine, UC Irvine.
Tell me about that one.
Well, it was a new experience for me going through the interview. And there were like 6 people, I think, that were applying along with me in the interviews.
And what happened?
I just never heard back from them.
But you did have an interview?
Yeah.
Tell me about the interview, would you?
Well, we basically went to the university and kind of toured the neuroscience labs. Different professors, and they said what their research was about. And then they asked me what my research that I had done was.
Do you think you interviewed well?
Not well enough, apparently.
But, I mean, you had some competition.
Right.
Do you think you interviewed as well as many of the other applicants?
I don't know. I didn't see the other applicants' interviews.
What do you think?
What do I think?
What do you think about the way you interviewed? Did you have an impression of how you did?
I think I came across as shy.
Was it comfortable in the interview? Were you comfortable doing it, or were you?
A bit anxious.
And it was your first job interview at that point in your life?
Like a long time.
Okay. We mentioned that you were Phi Beta Kappa. You were also a Dean's Fellow and a Regent Scholar at Riverside.
Right.
Cool. I have some the notes that you wrote in the jail, which I didn't realize I had, but I looked and I have them. You wrote a lot of philosophical stuff.
Right. I felt it was important to write it down.
I beg your pardon?
I felt it was important to write it down.
Yeah. I want to ask you more about that probably this morning, but can you tell me about when you wrote those things?
Before I got to Denver Health, so like in that period between getting arrested and Denver.
Okay. After you got back from Denver Health, did you write any more?
I think I wrote a poem and I wrote like a game I designed.
Okay, I remember reading about those. And how soon after you got back from Denver Health was that?
That was in December.
December of 2012, probably?
Yeah.
Okay. Since then, have you done some more writing?
No, stop writing.
Tell me about the urge to write, the impulse to write while you're in your cell.
I just thought they were important ideas to get down on paper.
Because? I'm not
There's
disagreeing
no
with
reason
you.
I don't think so.
I'm not disagreeing with you at all. I just kind of want to know how you thought of it.
Yeah, I just thought of it that way.
Through history, a number of people have written important things from prison cells.
I haven't looked into that.
But you're aware of that, are you not?
Well, I am now.
You weren't
I
previous.
didn't know that previously.
You didn't know that a lot of authors have written theories and novels and things like that after being locked up by the king or some such thing?
I think maybe Galileo did it or something.
Okay. Anyway, I found it interesting, and I'd like to go through some of that with you a little bit later. I also ran across a mention of a fellow named Jonathan Murphy.
Yeah, he was a graduate student in the second location I had.
Okay. Tell me about you and Jonathan Murphy.
Well, my desk was next to his, and he helped me with learning the procedures for some of the lab work.
Okay. Was he ahead of you or your same level?
He's been there like 3 or 4 years at that time.
Okay. Did he like mentor you or take you under his wing or just a friend or just a coincidental meeting? Co-worker. Somebody.
All right, I'm going to turn the lights back on. The record should reflect that the prosecution has paused the publishing of Exhibit P-TR-1009. Members of the jury, let's go ahead and take our morning break at this time. Please make sure you follow each of my advisements during the break, okay? Enjoy the break. I'll see you back here in about 20 minutes. Thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. By the way, I had a chance to think about the discussions we've had about People's Exhibit P-TR-1087 last night. That's the physical model of the theater, so I'll give you my ruling on that later today. All right, enjoy the break. I'll see you in about 20 minutes. The court will be in recess. Thank you.
Please rise.